Good morning, everybody. So, we're taking a report from Institute of Intellectual Property and Competition, 7 October 2021. And today we will go into discuss a subject concerned to the three-step test. So this test is under the Berne Convention, basically, and then they will open into the THUYom agreement, Article 13, and some other international treaty. So now we're going to see how this can implement into the national law, and that's very, very interesting matter for today. So the three-step test from the Berne Convention, that is the first step in international copyright law emerged at Article 9.2 of the Berne Convention. It served a cultural way to the formal recognition of general right of reproduction right at 1967 at Stockholm Revision Conference. The right of reproduction were not added to the Berne Convention. Only at the Stockholm Conference were already these various forms, and however, this omnibus right reproduction were recognized at Stockholm Conference. And then many options were considered before the country agreed on the three-step test as compromise solution. Civil law countries were more comfortable with a list of specific name exceptions, as they are found today in law of countries like France, Germany, or the Netherlands, to the name just three. So we have seen that many legal background concerned to the Berne Convention, and that then they will articulate to the THUYom agreement, the WIPO treaty, and some other things. A very complex issue. So we are going to see that some international law define the scope of the three-step test. Considering the historical background to the introduction of three-step test at the international level, it's become apparent that it is precisely the pro and relatively vague formulation of provision that enjoyed success during the Berne, THUYom, WCT, and WPPT negotiation. And then they settled down in the national law. So the first thing they mention is about the special cases. And then they will apply this agreement into very detailed international law in order to find what is the best way to implement the provision for the future. Therefore, a number of doctrinal proposals to rethink the three-step test more holistically along those lines have been pushed forward. It was proposed, for example, when evaluating the compatibility of an ENL with the test, to examine in its reverse, that is to start with the third step. The second step being examined afterward as a corrective measure to eliminate abusive conflict with the exploitation of work. It has been argued that the comparison of the wording of Article 13 of THUYom with other THUYom provision model on the three-step test suggests that the third step could be considered, and the most important one. And then it can another approach is to implemented into the U.S. law, for example, Article 107 of the U.S. Copyright Act, which codified the doctrine elaborated by U.S. courts in the 19th century. According to this fourth factor, the effect of the use on the potential market for or value of copyright must be taken into account in determining whether a particular use is fair immediately. One could say that the second step impact on normal exploitation of the work is one of the criteria to take into account during the analysis of the application of an exception limitation. So this step will open and open again into the US law and some other things. There's still a way to apply this position. So we are now taking something called illustrative cases, confirming the test role in creating sufficient room for social, cultural, and economic interests that have to balance against the rationale of copyright protection. The test has been used in an enabling sense in several court decisions. For instance, the German Federal Court of Justice underlined the public interest in unhindered access to information. In 1999, decision concerned the Technical Information Library Hanover, which offered support for libraries' practice of copying and dispatching scientific articles on a request by a single person and industrial undertaking. The legal basis of this practice were the statutory exception limitation for personal use in Section 53 of the German Copyright Act. Under this provision, the authorized user need not necessarily produce the copy herself, but is free to ask a third party to make the reproduction on her behalf. The court admitted that the dispatch of copy can flow to the publisher activity. Nonetheless, it refrained from putting an end to libraries' practice as conflicting with the work normal exploitation. Instead, the court deduced an obligation to pay equitable remuneration from the street test as compensation goes to copyright holder and enabling the constitutional information service in this way. So in 2002, the decision concerning the scanning and storing of press article for internal email communication within the private company, the German Federal Court of Justice gave a further example of its flexible approach to the three-step test. It held that digital press review had to be deemed permissible under Section 49 of the German Copyright Act, with to analog counterpart. If the digital version in terms of functioning and potential for use essentially corresponded to traditional analog product. To overcome the problem of an outdated wording, Section 49 that seemed to indicate the L&M confinement to press review on paper, the court stated that in view of new technological development, a copyright could be interpreted more liberally. The court arrived at a conclusion that digital press review were permissible if articles were included in a graphical format without offering additional functions such as attached collecting and an index. This extension of the analog press review exception to the digital environment, the court maintained, was in line with the three-step test as incorporated in the EU Information Society. Directive 2001/29. Similarly, in a decision dated June 26, 2007, the Swiss Supreme Court used the three-step test to propose an extensive and liberal interpretation of private use exception, including Article 19 of the Swiss Copyright Act, to legitimize the use of press article by specialized commercial services providing electronic press review upon demand to enterprise. To the court have that in order to guarantee the diversity of opinion needed for the free processes of democracy and permit the development of true information society, there were public interest in facilitating the making on and offering a fresh review by commercial services without having to obtain the authorization of each publisher. The church then went on to consider that even if the text of the law had been drafted with analog reproduction in mind, this application had to be extended to the digital world to achieve its objective. The court then examined in detail the solution adopted in light of the three-step test, and after having recalled to the content of the different steps, the Supreme Court held that the third step of tests were worded differently in different international documents, and it was not obvious that interests were be taken into account in this step. Why in the Berne Convention and why for treaty, the ENL but not cause an unjustified prejudice to the legitimate interests of the author. The TRIP agreement addressed the legitimate interests of the right holder as the interests of the author and those of other right holder are not always identical. It follows according to the court that three-step test serve to protect the author interests at least as much as those of the exploiter in receiving remuneration for its use. In 2018, Supreme Court of Colombia referred to the three-step test as included in Article 21 of Decision 351 of the Andean Community, in carving out a new exception to criminal liability for private non-commercial format seeking, using the three-step test as an overarching principle. The court held that there were no fundamental encroachment upon the exclusive right of the copyright owner, where the use did not conflict with the normal exploitation of the work and did not unreasonably prejudice the legitimate interest of the copyright holder. The criteria of the test were thus used to create an additional hurdle to be surmounted for a finding of criminal liability. The court concluded that in order to establish a criminal offense, it was necessary to ascertain whether the allegedly punishable acts were carried out with appropriate motive and the international intention to harm the work or the economic interest of the copyright owner. In the light of this standard, the court clarified that formal shifting for the purpose of private study and enjoyment did not constitute a criminal offense. Despite the risk already noted of incorporating the three-step test into domestic legislation as a standard to be applied in individual cases, court in jurisdiction where this has occurred have sometimes taken advantage to the presence of three-step tests to expand the effective scope of limitation. An example can be found in Spain with the Supreme Court in an attempt to safeguard search engine and catching services resorted to general principle of the law, such as the social function of property, the exercise of right in good faith, and the prohibition of abuse of right in its interpretation and application of three-step test. In megakini.com, Google Spain So you can see the case here, 2012. Google was sued for copyright infringement on the ground that this is a service involved the reproduction display of fragment of copyrighted website content and the accompanying touch service led to the reproduction of making available of entire web pages. The court concluded there were no exceptions available under Spanish copyright legislation to defend the unauthorized use of copyrighted material, but were seeking to create policies pay for the search services. The court found that the three-step test in the Spanish Copyright Act is not only have a negative meaning in the sense of setting for the limit of permissible exception, but also positive meaning in the sense of reflecting the need to set aside copyright protection in certain cases. The court ascertained whether in the individual circumstances of the case, the copyright owner experienced any real prejudice to their legitimate interest or faith on encroachment upon a normal reputation of the work. The court apparently showed the copyright claim as an attempt to receive damage for an unauthorized use, which in fact could be deemed beneficial for the claimant because it facilitated access to his web pages and provided information about his website. The court rejected the copyright claim because it amounted to an abuse and antisocial exercise of right. It found that its absence of any real prejudice, the protection of copyright may not be necessary to harm another party on the basis of what is considered unfounded allegation. So we have seen many international things related to this three-step test. So we go into some conclusion. The three-step test in international copyright law constitute a flexible balancing tool that offers national policymakers breathing space for creation of an appropriate system of copyright E&M at the national level, including the option to adopt open-ended flexible provisions relating E&L at the national level. At the 1967 Stockholm Conference for the Revision of the Berne Convention, the first step test in international law was itself devised as a flexible framework within which national legislators would enjoy the freedom of adopting national E&M to satisfy domestic, social, cultural, and economic needs. With the inclusion of tests in the TRIP agreement, the WIPO Internet Treaty, and the VIP Treaty, it had not lost its function to enabling tailor-made solutions at the national level. The WIPO Internet Treaty confirmed that the three-step test allow the extension of traditional copyright into digital environment and the development of appropriate new E&L. The abstract criteria of the three-step test offer room for different interpretation. The approach taken by WTO panel in the case of concerning Section 110 of the U.S. Copyright Act should not be seen as the final word on the test interpretation. Various interpretation approaches have been developed and in literature and applied by national court, including an understanding of the three-step test as a refined proportionality test. The use of each abstract criteria is factored to be weighed in a global balancing exercise and reverse reading to the test, stating with the last, more flexible criterion in light of the need to balance copyright and competition interest, in particular freedom of expression information. This flexible interpretation may prevail in the future. So that's your case of free type test. And if you have some discussion, please contact me. Nguyễn Thái Cường report from Institute of Intellectual Property and Competition, 7 October 2021. Thank you.